Hello, everyone. My name is Ravi. I'm a lawyer from Singapore. I'm not practicing in Singapore at the moment. I used to practice human rights law for 20 years. I will share more of my background as well as my work and the presentation later. And on to you, Craig.
Yeah, thanks. So what we're going to be looking at today is strategic litigation and its role in upholding human dignity and providing access to justice. I'm really hoping that we can add some value to everybody in the room. We've got an overview that will be presented about halfway through this presentation, and we'll be talking to that. But in the meantime, just a little bit of background about what I do. I've worked in criminal justice for 40 years, 30 years as a barrister in New Zealand, but also working across the planet on different cases. There are some takeaways that really, I hope, will stick with everybody that's here. And the first one is that human dignity is the soul of modern law. And on that basis, it must be the soul of business as well, because, of course, business complies with law. So it's that first concept that human dignity is that soul of modern law. So just hold that thought. The second aspect is that there are two superpowers in strategic litigation. And the first is collaboration. And that really means diversity. And through that collaboration and diversity, you're able to leverage the resource and get some significant power through that process. The other superpower is that plans in progress are power. So I'm really focusing on what are some practical ways that we can add value rather than just talking about what the problems are and all the components. So it's having a plan and working to a plan and progressing that. So there'll be tools as we get into this that I hope will be of some benefit to those that are interested. I think it's very important that that we start with a bigger picture and an overview. And that really sets the scope of what we want to talk about. And the first point is this, that many religions, cultures, and belief systems hold that from the first breath to the last breath, that there is a real alchemy, a living soul is created, and it's from that soul, that core concept of soul, that shapes legal and moral frameworks. And of course, those frameworks establish rights and responsibilities. So that's really the starting point. And this concept of soul in the law as a transcendent quality, and where the arc of law, the development, the evolution of law over time really bends towards that of the individual and the individual's rights and personhood, and really creates, it foregrounds the individual in legal frameworks. That's critical. So with the evolution of legal systems really bending towards the protection of individual rights, privacy, autonomy, and those sorts of concepts, that's where we're starting to focus what our action should be. Now, nation-states' authority comes from election and the support of the citizens, and a nation-state's power really is to monopolise violence. That's what it does, and primarily it does that through the criminal justice system. Now, human dignity is not just a good idea, it is law. Of course, it's international law in terms of the UN Declaration of Human Rights and the inherent worth of the person. And all business activities, production, procurement, recruitment, manufacture, service and supply chains, they're all governed by domestic and international laws. So they have an explicit and implicit human dignity requirement. So for businesses and individuals who violate those laws, the ultimate consequence and accountability resides in the criminal justice system. So that's really the paradigm that we're working with, that there is conceptually the individual, there's already laws sufficient within a system, and nation states have, through their criminal justice systems, that ability to enforce and to ensure compliance. So, what of strategic litigation? And I'm presuming that most people in the room understand what that is, but just for those that perhaps are unsure, strategic litigation or public interest litigation really doesn't necessarily involve winning in a court case, but it is linked to improved compliance and awareness of government corporate behaviour. And often strategic litigation cases are legacy cases. They're long, and they have a public application and they highlight systemic failures in individual rights. And our argument today is that that is a very, very powerful mechanism that's available to all groups. It's a generic and it's a transferable process, and it's best deployed as part of a collaborative model. And you'll see when we come to the model why collaboration is front and centre. So it's interesting here over the days that I've been sitting watching the presentations that people are talking about compliance and that government should do more and that this needs to happen and that needs to change. But in effect, what I'm saying is that everything's in place now and strategic litigation can provide the teeth to those organisations that want to engage in that process and against governments and corporates that breach their responsibilities. The thesis here, though, is that every breach of human rights has an endpoint that potentially can land in a criminal justice system. That's the endpoint. And that's often when other remedies have been exhausted, that the criminal justice system can be engaged and deployed. And it does need to be considered as any part of a compliance strategy. Now, having said all that and sort of framed up where we're going, I'd like now just to put on the wall what I call a flywheel, but it really just sets out all the different components of a strategic litigation process. I know that we've got very limited time, and I know that there's a lot of information up there, but through each of those components, I encourage you to dig down, and if you've got time, approach me after the session or through email contact, and we can talk through this process. But what I'd like you to do is view this as a flywheel, where you have the key message front and centre, the key questions. What is the desired result? What is the architecture of success? And so on and so forth. So in this diagram, and this has been used a number of times across a number of different corporate engagement, but also when acting for journalists that have been tangled up in difficult situations. And each of those separate factors need to work together. You can't have, in an arrangement like this, dissonant elements that are working against the overall engagement and action. So it's the collaboration of all those different actors moving around a central message, a key message or a key strategy. And while we call it strategic litigation, when engaged at this level, a litigation, the lawyering part of it is a small component. It's critical that the messaging and that the desired action sits at the centre of that. And it's about building momentum, and we're going to delve into some of the components of the momentum. But here, again, we can't have grinding and tension between those components. They essentially must work together, so there must be some consistent action. Ravi's going to talk specifically about some of the examples where this has been deployed, or his cases, and also some of the matters that I've been involved in. But in the time that we've got, I just want to look at the lawyers and advocates that are involved and engaged in this process. and what are their roles and the rights and responsibilities. So you can see that engaging a process like this always has a variety of different disciplines. And that's where the collaboration and the understanding of everybody's role in the process is fundamental. So, advocates, lawyers, specialists, experts in these sorts of processes operate really in a no borders environment. Much of the activity is across different borders, different jurisdictions, and rather than a dualistic or domestic only legal framework, generally you find that you're engaging multiple agencies in multiple jurisdictions, and when you're engaged in a strategic litigation process, that there's not the equality of arms that you'd expect in a normal domestic litigation process, that the equality of arms, certainly the power is on the side of the government and corporate, and is not equal in terms of those involved in this litigation process. The second thing that you find is that the regulatory frameworks are asymmetric and often in crisis. That means that there's a very thin or weak or two-tiered rule of law, and that sometimes often unfair, and that's just part of the matrix, that's just part of the fabric of how you are operating. Now, the third point is that all strategic litigation in this human dignity, human rights space has with it multiple resolution strategies. So there's multiple track strategies. It's not just a linear approach to tackling the mischief, if you like, that you're always employing multiple strategies. And you are working with teams in jurisdiction, that means in the country where most of the action is taking place, but you're also using a diverse range of lawyers and experts and advisors outside that jurisdiction. The fourth point, funding. And that seems to be front and centre of this conference as well, where the funding's coming from and how it's drying up, or where do we look to actually get some horsepower behind some of this action. I've found over the last decade of working in this space that there are very creative funding streams, and that would include media, if they have access to the case, if they have the inside running on certain witnesses or material that they can then create stories from. There's crowdfunding that's being used, there are donors, sponsors, there's all sorts of different funding models that can be deployed in a strategic litigation, and it's fascinating to see the stakeholders and the interested parties and sometimes just the random donors come to the party where they realise that what you're trying to do is a legacy and has public-wide interest, and that they will sometimes anonymously donate quite large sums to ensure that their action and momentum continues. I've already touched on the importance of having local partnerships in jurisdiction, and I mean, I guess that's the treasure of this work, that you're meeting people, lawyers and experts in different countries that have different modalities, that have different views and different approaches, and everybody gets welded together in a team, again, around the key message and that flywheel of momentum. Strategic litigation and the lawyers that act in these matters can be a masthead for the messaging. That means that they can stand there and say things and deliver messages that other bodies can't for fear of reprisal. And they can say things to governments and to corporates where parties that would be at some significant danger were to do that themselves. So I think that globally it's accepted that lawyers, when briefed, that is their job and that is the expectation, and certainly governments appreciate that. The whole idea that the legal team and the experts that surround them are a real centre of gravity for momentum, for ideas, for action that can be delivered. So I'm talking a very practical model. This isn't a theoretical or philosophical approach. This is saying these parts work when you start to deploy them in a focused and centred way. The role also for those that are interested in this can be one of education, advisor, auditor, and that can be an independent role separate to the litigation, but also ensuring that stakeholders, governments, corporates are educated on what the requirements are, how they're meant to comply, and the consequences of them not doing so. The next point, the eighth point, is that, I mean, it sounds trite, doesn't it, but the sensitivity to cultural practices, to the politics and to the economic imperatives is critical, that you're working in environments that require that, they're different across different jurisdictions, and that's part of your armamentarium, that's part of the resource that you've got, and critical that you're sensitive to those aspects. The ninth point, in this game, in strategic litigation, you are inevitably going to find global and privatised media that run a counter-narrative to what you're trying to achieve, certainly in the political arena, where they'll be trying to sell advertising and clickbait, which will run contrary to your central message. And you need to be prepared for that and have a media strategy that engages that. As I said right at the beginning, this work means that human dignity, a human dignity-centred approach, is critical. It's about the individual, it's about protecting their rights, the personhood. You know, it's that soul of law that sits at the centre of your work and is so important. There'll be issues about practicing certificates and standing in courts and standing in the different arenas that you'll find yourselves in. That's a very complex area, and that's why we use in-house counsel in jurisdiction. But there are, again, ways around dealing with matters such as interim or multiple practicing certificates. And I guess that's a very long discussion for those specialist lawyers that are interested, and I'm happy to talk through that. But from country to country, obviously there are different regulations, there are different roles and rituals, and they need to be complied with when you're engaged in this process. So, again, this is we've got a very short time slot, and I'm trying to deliver as much information as I possibly can. Before we get to examples, I've always viewed this work as being like a musician in a band, where the whole is greater than the sum of parts, that there are so many different people and so many different cultures all are working together on the same song sheet around that key message. You're building momentum, you're understanding where the problems arise, and you're mobilising all the resource that you possibly can towards that goal. Anyway, that's it in a nutshell. I know we've meant to only have another 5 minutes or so, but I think Ravi now is just going to talk a little bit about some of the work that he's done. What I can say is that we've used this in the fishing sector, we've used this in all sorts of different realms, and more than happy to talk to those that are interested in working in this area and developing it further. So Ravi, could you just perhaps...
A very good morning, everyone. I'm M. Ravi. I used to practice for about 20 years in Singapore as a human rights lawyer, particularly in the field of constitutional law as well as death penalty cases. And currently, I lead a law firm, Ravi Law, a regional practice in Bangkok, which deals mainly with ESG-related matters and AI governance and other sectors of the law. Drawing from the inspiration of this flywheel, and I will say at the outset that this wheel can only move if we go beyond consulting, if we go beyond consultancy to build as architects of accountability. That is the inspiration that we must have for this wheel to move. And allow me to share my experience in a very difficult climate, like a place like Singapore. I say this because, the wheel is there for us as a model, as an architecture to follow, but we are dealing with very different political climates where activists face danger, lawyers face danger, and there are repressive political environments, largely in Asia Pacific, in this part of the region especially. And so I would like to relate my experience and my journey, which I think that speaks to the core of this wheel. About 20 years ago, in 2003, I started off, my baptism of fire was ignited through a first death penalty case. And all these cases that I've been involved generally were cases that come to the last minute, late state applications just before the execution is going to start. So when all the cases have run its course. And it's very, very difficult to actually win any of these cases because they have essentially gone through the process already. So it was all difficult cases, and most of these cases were dismissed and the clients were led to executions. And the positive side to this is that over the years, the death penalty campaign, there was a momentum building up. Fast forward, in 2009, I represented a young Malaysian, Yong Wee Kong. He was only 19 when he was when he committed the offense of drug trafficking in Singapore. And just 2 days before the execution, I filed an application for a stay of execution. The legal challenge, the court granted the stay, and the legal challenge continued from 2009 to 2012. I mounted a series of constitutional challenges, and repeatedly these constitutional challenges failed in court. But other executions were also stopped because of these constitutional challenges. There were so many of them who were facing execution for a period of 3 years. There was largely a indirect moratorium on the death penalty. Although the challenges failed, they highlighted the systemic failure in the system, and the government was very, very clear and very reticent on the fact that they are not going to bend. So in this process, looking at this wheel itself, there was online media championing these issues. State media, is largely controlled by the government. The international media weighed in, and United Nations, there were some statements coming from there. I had the support, particularly from Death Penalty Project, and lawyers from London and lawyers from Doughty Street Chambers, barristers' chambers, who are specialists in this area, supported me with their legal submissions. Although there was no funding, because I did the matter pro bono, but it was largely taxing because it went for 3 years. Despite, as I said, the very firm stand of the government, the glass ceiling finally cracked at the end of this journey. In 2012, the Singapore government amended the Misuse of Drugs Act. Yong Wee Kong, the courts were given some discretion, and Yong Wee Kong was the first one to be saved from death penalty. And there were others who also benefited from that change. Talking about transnational litigation and the impact of it is not just in one jurisdiction. This case became also a catalyst in Malaysia for reform of the mandatory death sentence in Malaysia as well. And this ignited another a row of campaigns in Malaysia, and in 2023, Malaysia abolished the mandatory death sentence and gave full discretion to judges. So I just wanted to bring this inspiring example in a very difficult setting like Singapore and to a certain extent Malaysia itself, how this flying wheel was in full operation and was in incredible motion. Just drawing a very recent example is the case of a defamation case which both Craig and myself are dealing with. It is closer to the topic, which is corporate accountability. The online outlet Diplomat, which is an international outlet, was recently, about 3 months ago, where they were sued as in a legal action was commenced against them on allegations of corporate accountability or corporate abuses by a Cambodian conglomerate. And I won't go into the details because it is only at the letter of demand stage. So they issued a letter of demand from Singapore. Strangely, it was coming from Singapore when the company was actually in Cambodia, and they were threatening legal action across multiple jurisdictions. So the matter came to me. As I said, I'm based in Bangkok, and I thought, looking at this wheel, of course, this wheel came belatedly to me, but the first thing I have to ask myself, where are my resources? Because this is going to be very heavy. You're dealing with a conglomerate. You can't deal with a small team. So I've known Craig for about 10 years, and I contacted Law Aid International, whom I'm also part of the international chambers, which I was privileged to join recently. And we teamed up together and developed a strategy, and we framed this action as SLAP, Strategic Legal Action Against Public Participation. And we thought that was the best way to give a slap back on this defamation action. And it has stopped for now. But the fact that I'm already beginning to speak about it, we don't know to what extent the next stage will develop, but the momentum is already building up to develop a support network and the energy that is developing even from the sharing session that we are having now. Well, because of the constraint of time, I would love to, of course, share more examples, and we can take questions now.
Yeah, and if nothing else, this may just be a checklist for you to go, have a look at this, what about this resource, what about this? For each of these, I have a toolkit or a toolbox that we can sort of drill down on. We can't do that today, but I can say that this was a model that we acted for thousands of Indonesian fishermen in New Zealand, had the law changed, got people paid, but it's the momentum, it's the collaboration that creates that superpower. And we're always keen to talk to people or have people interested in this to join with us and do whatever's required. So thanks for your time. Questions, comments, queries? Please approach me later if you want to, either by email or in person, and we can discuss further as need be. Thank you.